Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today we're talking about refugee claims. Cases that should have gone to the Supreme Court of Canada, but didn't. Frederick Hackie Zimana applied for refugee status in Canada. He had already obtained refugee status in another country, but was applying to come to Canada as a refugee, fearing persecution in the country that he had already achieved refugee status in, as a result of fearing persecution in his home country. Mr. Hackie Zimana's application for refugee status was originally denied on the basis of the fact that he had refugee status in another country, and Canada can't grant refugee status to an individual who is already a refugee somewhere else. And this case raises very important issues. We see political cultures changing in other countries. We only need to look south of the border to see the way that the United States, once considered a safe third country for individuals from the queer community, are probably likely to be subject to significant levels of persecution in that culture now. And so when a country grants refugee status, but then the circumstances in that country change to make you subject to persecution, should you not be able to apply for refugee status in a better country, in a country that's more likely to protect your rights and not discriminate against you on the basis of your individual identity or your religion or your race? This is a very important issue. What's even worse is that in Mr. Hackie Zimana's case, the federal court dismissed Mr. Hackie Zimana's appeal on the basis of the fact that by the time the matter got to court, he had already achieved permanent resident status in Canada and so no longer needed to make a refugee claim. But the Supreme Court of Canada doesn't have to be bound by questions of mootness. Because their concern is issues of national importance and significant legal issues, whether or not it was moot in relation to Mr. Hackie Zimana didn't prevent the Supreme Court of Canada necessarily from commenting on this very important issue, because evolving political landscapes in other countries place other people at risk. And in Canada, we should try to protect as many people as possible from those types of risks and should understand the way that politics can change elsewhere as well as in our own country. The Supreme Court of Canada really missed an opportunity here, and unfortunately this is the type of case that's going to lead to real danger for other individuals who may be seeking refugee status in Canada after having already escaped a country and obtained refugee status somewhere else. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.